Right, you tell me when, hey, Betty.
I will do so, sir.
All right.
Judge Hussain?
Okay, do we start, Betty?
Yes, please, sir.
Okay. Um, you don't want to wait a few minutes, Betty?
How's your power going on?
It's okay.
Is it okay?
Yeah, I think
Um,
it will run the full 3 hours.
Then we can wait. We on 64. We need to be 78.
Okay, just give it another minute.
Okay, sir.
Okay.
Judge Hussein, I think we should start.
Okay, thank you. And good morning and welcome to this webinar. Before I start, I have to deal with the unfortunate consequences of corruption and incompetence. Most of us on this program will experience loss of power. Now, I'm hoping we can all remain connected, but if you do have a problem, the session is being recorded and we can, depending on how many people couldn't attend the whole thing, Betty Lubber, who's the coordinator for this, will arrange for the recording to be played back for you, for your benefit. So don't be too worried. You can attend, even if it's parts that you missed. You can get a recording of that. Betty Lubber will attend to it. Okay. Now a little bit about this course. It's called Litigation Strategy. Now, I call it that because my experience has taught me that many practitioners, attorneys and advocates, get this wrong. The focus is wrong from the start, and we end up with this problem in court. And all of you would have experienced it. If you go to court on day one of a trial, be it a civil or a criminal trial, doesn't matter. 9 out of 10 times, someone will ask for a postponement. Why? Because they're not ready to start. Why? Because they followed the wrong strategy or technique from the start. Now, this is probably one of the most important courses you will do. It's such a pity that we have to do it virtually. I'd prefer to do this with you in an auditorium, but we'll do the best we can. Now, Why is it so important? It's because the core function of lawyers is to resolve disputes. Now, I can tell you, the legal profession is under enormous pressure in the sense that in the past, when I was a young practitioner, a young attorney, and then a young advocate, we didn't have much competition from other professions or from outside the profession. Now you are competing as lawyers with various outside professions like accountants. Uh, Accountants are make up some of our most our strongest competition. They do the work of lawyers. Um, Even institutions that we use, like banks, insurance companies, they're doing the work that lawyers used to do. Like the banks are doing wills and estates. Even the insurance companies are doing it. Um, so the world has changed. But one of your biggest competitors is the internet. Um, the other day I was talking to a friend who is a doctor. He's a specialist. And he said to me, he said, Ismail, we have now become a profession of second opinions. Where's the first opinion coming from? It comes from the internet. Someone has symptoms, put it, they Google the symptoms, it comes up with the diagnosis, and they go get the medicines and so on. And then when things go horribly wrong, they go to the doctor. Now, the same thing is happening with us. People look in the internet for answers to their legal problems. They think they can sort it out. And then when things go wrong, they come to you. But there's one area of legal practice where we are not easily substituted, and that's litigation or dispute resolution. People get into trouble, they get involved in disputes. They need the services of a good lawyer. And what this course is about making you a good lawyer. So let's get started. My view is that dispute resolution, from the point of taking instructions to final argument in court, is really the pinnacle of the legal practice. Okay. The litigators are the ones that are in the public sphere. We're in courts. We're on television. We are performing in public places. It's not like winding up a deceased estate. I mean, God's sake, that's so boring to start with. I mean, I don't know why you want to do that after spending so many years studying, but I suppose someone has to do it. The really exciting part of practice as a lawyer is dispute resolution. But if you don't get it right, if it can be a nightmare. Litigation can be an absolute nightmare. And these days, judges are quite happy to penalize the lawyers with cost orders. When I was in practice as an attorney and as a junior counsel, years back, judges hardly ever penalized members of the profession, that's advocates and attorneys, with cost orders. We were colleagues. The fraternity looked after each other. Well, that mindset is going away. In fact, it is due to the fault of the profession that judges have adopted a different mindset. Now, I want to show you how you change your own mindset to fall into modern litigation and modern dispute resolution. You all know about the rules, the uniform rules, the practice directives, and so on. This course is not about that. This course is about what you do as a lawyer. It's practical, and I can assure you, when you finish this course, you will be able to put into practice what you learned here immediately. The next day, you can go into your practices and you'll start getting it right. But I must warn you, litigation is not for lazy people. Okay, you are going to work very hard. It takes a lot of application, and you have to be enthusiastic about the work you do. It is financially rewarding, but if you get it wrong, it can be a disaster, as some of you may have already found out. It's about applying your mind every step of the way. You know, when I started in practice as an article clerk, the first thing I noticed is that the lawyers are relying heavily on precedents for everything. Look, if you're a commercial lawyer drafting contracts, then you must use precedents. Those precedents are developed over time, and they they enable you to draft contracts efficiently and at a reasonable price. Litigation's not like that. But I've come across many practitioners who are in dispute resolution who are copy and paste experts. Now, once you do that, the first thing that happens to you when you copy and paste from a precedent, that's within litigation, that is, you copy and paste from someone else's particulars of claim, from someone else's heads of argument, from someone else's affidavit. The worst thing that happens to you is that you cease using your own mind. You stop thinking on your own. You stop applying your mind. Now, please get this straight. Being a lawyer is about applying your mind every step of the way. And I'm going to show you how you do that. Now, there are a number of things that had an impact on the profession. I spoke about the internet and the competition, but for many years, people like myself, we got paid for the work we did, irrespective of the result. So you went to court, you ran the whole process, you charged along the way, you got paid, even if you lost the case. Okay? Your client lost and got an adverse cost order, but you submitted an invoice and you got paid. Well, I can assure you that has changed. It has changed in a big way. In other countries around the world, like the UK, especially in America and in Canada, contingency litigation was introduced many years ago. In this country, it's fairly recent because the Law Society banned it. It was unlawful. Although everyone knew that it was happening, and we were pretending it didn't happen. Well, contingency litigation is here to stay. Now, what does that mean? It means that you get paid only if you succeed. That has had an enormous impact on law firms, especially if you're a law firm that's engaged in disputes around contract and delict, and more particularly delict, where you sue for damages. This impacts on the law firm because the law firm has to carry the disbursements all the way up to judgment. Now, obviously, if you don't succeed and you don't get paid, it's an enormous loss. To begin with, the disbursements that the firm put up is lost. You never recover it. And then there's your fees. That's going to be a write-off. So the techniques I'm going to show you here will make you more successful. Now here's the first mindset, change of mindset. Litigation is not about cornering the other side. Litigation is about resolving a dispute between two parties, and you want to resolve it quickly and cheaply. Adopting an adversarial approach towards litigation now will only get you into trouble. Just stop it. Okay? Now, I will show you how to become less adversarial. Now here, I'm going to take you through what I call the three principles of dispute resolution. This is the first principle. Lord Brown Wilkinson is an English law lord, a judge, and he was interviewed by an author writing about the work of the judiciary, and he asked the judge, what would you consider to be the first principle of litigation? And this is what he said. He said the first principle of judging is dirty dogs don't win. Now I want you to think about that. What does that mean? It means that if you represent a client who has a non-meritorious case, but nevertheless wants to go to court because the client can afford it and because the court is there, it's just because they can. We now recognize in the modern world, judges recognize that courts are there for their scarce resources to be used only in legitimate disputes. We all know, and I'm not taking an ivory tower approach, I've done it myself. You get a client, you say, what's your case? They tell you, and you realize immediately, this is rubbish. Okay, it's BS, it's not going to work. So you tell client, listen, well, some attorneys, because it starts with the attorney, they take the instruction, they say, right, we'll issue the summons, or we'll file a notice to defend, knowing that there's no merit. But they did it because we all got away with it when we got to court and a judge says, listen, this version of yours is not sustainable. How do you explain this? The lawyers had a stock response. They said, well, my lord, those were my instructions. Well, when you go to court with a really bad case, your client, and in the eyes of the judge, you and your client will be the dirty dogs. And trust me, I've had 41 years of courtroom experience. When you go to court with a version that is not probable, not likely to have happened, you are going to be disbelieved and you will lose. My experience is that dirty dogs genuinely don't win. Oh, sometimes they succeed. They're very good at getting postponements. They're very good at tendering costs. All of that stuff they can do. But when a judge gets hold of the merits of the matter, they don't succeed. Now, before I leave this point, there's a very good article that you should read. It's written by Judge Owen Rogers. It's about the non-meritorious case. He writes about the ethics of a lawyer taking on a case that has no merit. Okay, you get paid, of course, you get a fee, but your reputation will suffer. A lawyer who takes on genuine disputes and resolves them quickly and cheaply is the best lawyer. I don't care about how flamboyant you are, how smartly you dress, how eloquent you are. Good lawyer is the one who resolves his client's case quickly and cheaply and does not go to court with a version that is improbable. That's the start for you. If you're young and you're starting this career, that's the first principle. The second principle, facts are the most important part of the case, not the law. You know, when you were at university, what you studied was law. It was academic law. Now you're going to practice applied law. You can only practice applied law to a set of facts. Law cannot be applied in a vacuum. It must be applied to a set of facts. As a lawyer, you must know what happened according to your client's version of the facts. Without that, you're not starting. So when you get this version, and after careful analysis, you are convinced that this version is not likely to have happened. It's improbable. You can test it in a different way and ask yourself, if I present this version in court, will a judge accept it? If the answer is no, then, and your client tells you, please proceed to court, here's a deposit, your client is a dirty dog, and your client is going to lose. Now, how do you deal with this as a young attorney? Now, on the one side, you are tempted by the fee. On the other side, you have a client who comes to you with a non-meritorious case. In other words, there isn't really a dispute. He's litigating out of vexatiousness, out of bad faith, or he just wants to mulct the other side in costs. So you have to decide whether you want to take this case or not. Okay, so you say you know that this case is not a good case. So as a prudent lawyer, you will not take it on a contingency. You will say to client, I'll take this case, but you are going to put down a big deposit. Now, it's all very well. You'll make some money. But if you do end up in a courtroom, your reputation will go down the drain. And now let's give you the bad news, the really bad news. When you lose, and you will, if you've got a version that's rubbish, you will lose. Guess what happens now? You present your client with the bill, and your client blames you for losing the case. Client will say, but you didn't tell me the judge will adopt this view and throw me out. If you told me that at the beginning, I would not have insisted on going to court. Now, here's a practical tip. If you do get a client who insists on going to court, is willing to put down a deposit, tell him in writing. Give him a memorandum to say, I've made an assessment of your facts. For these reasons, your merits are poor. If you nevertheless want to proceed, then instruct me to proceed nevertheless by signing at the bottom of this document, or something like that. Just cover yourself. I've also seen many cases being reported to the LPC by clients who lost, blaming the attorney. Yet when you look at the merits, you can see why the client lost. They were on a loser from the start. The third principle is never go to court with a version that is improbable. First, get the version, number one, because those are your facts. Don't bother with the law now. Look at the facts. If it's implausible, you're out. You're a dirty dog. Now, I'll deal with this in more detail later, but let's start with something very basic. When you go to court in a civil trial or application, the test is that you must prove your case, whether it's your cause of action or your defense, on a balance of probabilities. That's what it means. On a balance of probabilities. Judges are not there to find the truth. And the reason for that is, in an adversarial inquiry like our trials are, a judge will never know what the truth is. And it's not his job to find out what the truth is. All a judge needs to do is to find out if the version relied on by the parties, by the one and the other, is plausible. If it is not probable, the judge rejects it, you lose. That basically is what is meant by proof on a balance of probabilities. Just to illustrate this further, when a witness testifies in court, Mr. Mokoena is testifying. If a judge says in his judgment, I've heard Mr. Mokoena, I listened to his version, I was impressed with him, I think he was a good witness, I find that he told the truth. Okay, let's analyze that. Now remember, the judge doesn't actually know if Mokoena is telling the truth because the judge wasn't there. You are not there. You don't know if your client is actually telling the truth. Very often we're convinced that our client is telling the truth, but really you don't know. But what lawyers can do, what we do know, is that we can make an assessment of the probabilities of our client's version. And I'll show you how we test that. Now, when a judge says, I find that Mr. Mokoena told the truth, what he is saying is that for purposes of this hearing, I am persuaded that he told the truth. The judge is not actually saying that is the truth. He's saying, I am persuaded for purposes of this hearing that it is the truth. And it goes no further than that. Now, if you're the dirty dog and you came to court with a version that's improbable, a judge just disbelieves it, and you lose. So, those are the three principles, and never forget it. It will guide you through your careers. As far as the mindset is concerned, we have to stop being adversarial. Now, South African lawyers are adversarial animals. Why? Because we were trained that way. We were trained that you have to be as difficult as possible with your opponent. You must deny everything. Don't admit anything. Okay. Respond to correspondence when you feel like. Respond to court notices when you feel like. Do everything only after you are compelled. Now, I know some of you are smiling right now because you are one of those culprits. We were all those culprits. Trust me. We all did that. You have to stop. Now, just let me illustrate this. I say that modern lawyers in modern litigation are not adversarial lawyers. You've all heard of this thing called case management. We've introduced it in our courts. The only problem in this country is that we have no uniformity in the way we apply it. Every court, and indeed every judge, has their own way of dealing with it. So it's very hard to navigate, simply because there's no uniformity, so it's not predictable. I know judges who are excellent at case management. Usually those are the judges who wear silks, very experienced courtroom lawyers. They know what to do. Unfortunately, we have judges on the bench these days who have never been in a courtroom before. The first time they appeared in a courtroom was when they got onto the bench. And you really struggle with them. They just have no idea what to do. You'll experience this. Your job is to assist them. Now, what is case management about? Now, you've seen all the directives that are issued under case management. And what it does is that the judges are trying to resolve the dispute quickly and at a lower cost. That's the whole idea. So they write directives to facilitate or advance the case between the parties. But in truth, what case management does, it's not about managing the case. It's about managing the lawyers. Case management is aimed squarely at making the lawyers less adversarial, more cooperative. You want to cooperate with your opponent. You know, I've run hundreds of trials. Very often, I spoke to my opponent the first time at a pretrial conference, 2 weeks before the hearing. Until then, never spoke to him. We wrote to each other letters and correspondence and so on. Not even a phone call. And it doesn't work. It's too adversarial. At the pretrial conference, you get a list of admissions. Ask your opponent, will you make these admissions? He says, no, I admit nothing. And they got away with it. Well, you're not going to do that anymore. Your job as a lawyer, as a good lawyer, is to assist your client. Act in the interests of your client. What does your client want? What is in the interests of your client? Resolve the dispute quickly and cheaply. This is not about abusing the processes of the court to get at somebody else. That is gone. If you can still do it, but I can assure you, you are going to get into trouble. Just stop it. So here is the onus. Onus is very important. Onus is something you apply your mind to from the start. Now, let's be honest. When you write particulars of claim by copying from a precedent, and by the way, we're in the 21st century, and I still see lawyers copying from the wrong precedent. I promise you, I was in a full bench hearing on Monday this week, and my opponent presented a document to the judge with the wrong case number on it. And it turned out that he copied and pasted from a precedent, and the information on that precedent, which is irrelevant to the case at hand, was copied as well. You know, that's unforgivable. You should see what the judges did looking at this colleague who handed up a document that came from copying and pasting. It's just hopeless. Okay. Now be honest, how many of you at the point of drafting particulars of claim applied your mind to the onus? Now, if you are writing particulars of claim, you are going to present a version. Your particulars of claim will contain the material facts that you have to prove in order to succeed. So what happens now? You draft the facts. A good lawyer will say, can I discharge the onus if this matter goes to trial? And remember, when you draft particulars of claim, you draft on the basis that the matter will go to court. Now, many lawyers draft papers on the basis that, this will never go to court, we'll settle. Well, I promise you, those are the ones that end up in court. And then you're in trouble. So treat every case as if it will go to trial. So at an early stage, in fact, before you issue the summons, you have to apply your mind to the onus. Can I prove those material facts? Now, what does this mean? How do you discharge the onus at a trial stage? So I'm going to take you through a 4-part strategy. When you start, I told you, you've got no chance of satisfying the onus, whether as plaintiff or defendant, if your client's version is not likely to have happened. In other words, it's improbable. You're not going to succeed. Okay. This attitude of let's test their case and see where it goes, it won't work anymore. Why? Because if you plead a version that is not likely to have happened, you'll end up before a judicial case manager, a judge, in chambers. They're going to read this and say, but hold on, this doesn't make sense. What are you getting at? What is your version? Now, if you are not satisfied, sorry, if you are not satisfied that the version is sustainable, you are not going to succeed. I can assure you, you will not succeed. You will not discharge the onus. Don't proceed with adversarial litigation if you are not happy with the version. Now let's look at the 4-part strategy. And then we'll deal with each strategy as I've put it down there. Firstly, the process, the first part of the process involves taking instructions. Now, we all say this. We take instructions. When we write letters to each other, we say, we are instructed that, or our instructions are. 9 out of 10 times, client never gave you those instructions. Lawyers just write the stuff. What is meant by taking instructions is not signing a mandate, a power of attorney, and giving you authority to issue a summons. That's not it. That's the administrative side. Taking instructions means obtaining all the relevant available facts. That's the first part. The second part, once you've got the facts, You have to formulate a cause of action or a defense, and then you must plead it correctly and persuasively. That's another way of saying, do not use a precedent. What you want is to draft the peculiar facts of your case. The problem that judges have, and I've experienced it on the bench as well, when judges come to court, or before they come to court, they read the pleadings bundle, or they read the 3 sets of affidavits. They would like to know, what is the issue? What am I going to do in this trial? What am I expected to do? What am I resolving? They need to know that. Now, if you used a precedent to draft your particulars of claim, it tells the judge nothing. Promise you, it says nothing. You are in trouble before you walked into court. The third part, it goes logically. Facts first, proper pleadings, and then the third part is the pre-trial procedures. They are very important. And a lot of the case management gets focused on it. Things like discovery, experts, attending case conferences and pre-trial conferences, and judicial case management. This is the phase where the parties prepare themselves to go to trial. Now, the whole idea behind that third phase is for you to try and resolve as many issues as possible. You want to avoid interlocutory applications and interlocutory disputes, and you want to go to court because there's a genuine dispute and you are able to identify it. That's the important part. You are able to identify it. Those of you who have been with a good case manager, you will see that what they do is that they spend a lot of time asking the parties to pinpoint the issue between them. And many of our judges will insist that you write it down. They'll tell you, don't refer me to the pleadings. Write it down. What you agree is the issue between the parties. You know, you can test this. Go and read the pleadings. Draw 5 random files in the High Court or even the Magis Court. Read the pleadings. Put it down and ask yourself, what's the issue? You won't know. I promise you, you won't know. Because the particulars came from a precedent, and the plea, the defense, is a bare denial. So it doesn't tell you what the issue is. You don't know. And the worst thing you can do as a lawyer is embark on litigation where you have no idea what the issue is. You're going through the motions, and that's a bad lawyer. The fourth phase of dispute resolution is the trial itself. Now, what happens at trial is influenced 100% by the first 3 phases. You can only succeed in a trial if you know the facts, if you pleaded them correctly, if you prepared yourself through discovery and pre-trial conferences, you've identified the issue. Now you'll be ready to call your first witness. Now let's deal with this thing. Now, before I go any further, let's look at the practice directives. You have to read the practice directives of the court where you are bringing the application or the action. Now, all the divisions, there are people attending here from all over the country. You have to be familiar with the practice directives of the court where you're issuing your papers. where you issue process. My advice to you is read the directives before you issue summonses, before you go to the registrar, or before you enter it onto case lines. Don't take a chance. Look, we know what the uniform rules say, or you're supposed to know. But now it's essential to know what the practice directives say. For example, in the Gauteng local division, if you are starting an action where you will be using an expert, you are supposed to note that when you issue your summons. The registrar will then allocate you a special case number with an E in it, so that just by looking at the case number, the judge will know there are experts involved here. You see, I mean, if you didn't read the directives, if you say from another province, or you're from Gauteng, but you don't read the directives, you won't know that. Okay, it's not in the uniform rules. For purposes of any action, you have to comply with case management. You want to know how case management is practiced in your court. And then, many of our courts, not all of them, many of them, Gauteng, for example, Western Cape, KwaZulu, they have a process of trial certification. So in other words, you don't get a trial date if you are not certified trial ready. What happens in this process? Well, it's not uniform. It's different in every province. But what it really means is when you are certified trial ready, it means that on the day of the trial, you can go to court and at 10 o'clock, you're ready to call your first witness. That's what it means. It doesn't mean that you go to court and you ask for a stand down, ask for time to talk to your opponent, seek a postponement, and so on. In this province, you are told that once you're trial ready, certified, you are not going to easily get a postponement. You know, in the past, you got a postponement just for asking. Or if you agreed with your opponent and you tendered the cost, you got a postponement, not a problem. That has changed. Judges will want to know, why is it being postponed? Forget about an agreement, forget about cost orders. The judge wants to know, why are you not ready to resolve this dispute on the merits? And you'll get into trouble, okay? You must know how to attend case conferences. Now you have different types of case conferences: judicial case conferences, what we call case management conferences with a judge, and then you have case conferences with your opponent in the absence of a judge. There are directives dealing with discovery, experts, containment of issues. If you fail to comply with directives, it just results in wasted costs. Okay, you want to avoid that. So you want to be non-adversarial, as I told you. The idea is to go to court and utilize scarce resources only when it is necessary. Now, we've put in various directives and even amended the uniform rules to try and make lawyers less adversarial. Now, I will deal with this in some detail, and that's Rule 41A, which was introduced, and I don't know why it took so long to introduce here. If you look at the UK and in Canada, the United States, Australia, they've had that system in place a long time ago, more than 2 decades ago. That's how late we are. And then I underlined something there. I want to emphasize it. Avoid interlocutory applications where possible. They do not advance your case. It's all about time wasting. But more importantly, to the lawyers who engage in interlocutories, it's about writing fees. I can tell you, interlocutories happen only because someone didn't do their job. For example, if there's an application to compel discovery, it means that the attorney on the other side didn't do their job. So what happens? Plaintiff's attorney issues a notice of motion, first a letter, then a notice of motion, there's a supporting affidavit, the attorney on the other side receives service, reads the papers, and guess what? He caused the trouble, but now he's going to charge his client for reading those papers. Do you see how terrible this is? Client didn't cause a delay in discovery. The attorney didn't bother. But now he gets an application to compel. He sends his client a bill on perusing application to compel. Clients don't know what this is, so they pay it. Okay? That's terrible. You can't profit out of your own incompetence or laziness or negligence. Well, we are addressing that in case management. One of the consequences of case management is that the motion court role shrank. It got smaller because what occupied the motion court roles were interlocutory applications, and we still have too many of them. I looked at the motion roll for next week. I was happy to see that under interlocutory applications, there were very few cases. We used to have 50, 60 of them at a time here in Johannesburg and Pretoria. Do not bring interlocutories. What's better? Talk to your opponent. Send him a polite letter. Ring him up and say, listen, but your affidavit is due. I have instructions to compel, but please, can you file it? Can you file it by Monday? And most of the time, your opponent will agree. Okay. So that's what happens in court. For example, if you brought an application to compel, but didn't write a letter to put the other side on terms, a judge will give you an order, but he'll disallow your costs. You are being too adversarial. High courts all over the world are discouraging needless adversarialism, encouraging parties to settle. Where settlement cannot be reached, then the parties are expected to reach settlement on the issues for trial. So you must have a common understanding of the issues. You must write it down, and that's what the judge is going to deal with. You are also now not only expected to apply your mind to ADR, alternative dispute resolution, but you are expected to, you are forced to look at ADR. And that happened with Rule 41A. So settlement and mediation must become part of your litigation strategy. We've got 41A, where you are compelled to comply with it. You see, the problem is we had ADR for decades. It didn't work. Why? Because ADR in the past only happened if both parties agreed to use it. If one of the parties said, I'll see you in court, I'm not interested, there's nothing to mediate. I'm not going into arbitration, I'll see you in court. So one of the parties was able to easily frustrate the other. Well, that can't happen anymore under Rule 41A. You'll see in a moment. Practitioners are expected to cooperate. Let me give you an example. In a pre-trial, your opponent says, will you admit this fact? Well, you look at it and you say, well, I'm not admitting it. I'm denying it. But you cannot give your opponent a basis in fact or law for the denial. It's just a bare denial. So now you go to court and your opponent calls a witness to prove that fact. You don't cross-examine. Why? Because you have no basis to challenge it. So you don't cross-examine. What do you think is going to happen now? The practice now, and judges are being trained to do this, the judge will immediately say to you, listen, why did you not admit this fact? Why did you put your opponent to calling a witness when you could have admitted this fact? Because you didn't challenge the witness. You will pay the costs of calling that witness. That's what's going to happen. Now, a very good case, in fact, it's the first judgment on case management, is this case of Brownlee versus Brownlee. It's now known as B versus B, but they published it as Brownlee versus Brownlee at first. It was a mistake because this is a divorce, as you can make out, and it involved children, so we're not supposed to put the names, but it doesn't matter. What happened there? It's a divorce. The court file was enormous, huge court file. The matter went to trial, and they had a very good judge, was a silk, looked at this file, went through it, and realized what happened here was the two firms of attorneys were just having a go at each other. This thing got out of hand, but the worst thing that happened is that between the two law firms, they absolutely exhausted this couple's finances. Okay? The money was, both their estates were all gone into costs. All because the lawyers refused to cooperate with each other. You know what happened? Go and read the judgment. The lawyers had all their fees disallowed because they ran up costs when it was not necessary to do so. So just beware. If you become too adversarial, you are going to pay a price. You might end up paying the costs de bonis propriis. Be careful. Now, let's go. I'm going to take you through 41A. I'll do it quite quickly because it's very simple to understand. But as an opening statement, what I want to say to you is 41A is not there for you to merely comply. Now, here's the thing with lawyers. They took the uniform rules. The uniform rules will say, this is what a party must do. Now, every uniform rule has behind it a purpose. And the idea was for the lawyers to achieve that purpose. Otherwise, the rules are no longer fit for purpose. Now, it became obvious to judges over the years that the lawyers merely comply with the rules. For example, the rules say you must hold a pre-trial conference. So they had one, but they didn't do anything. They met, had coffee or tea, discussed very important things like whether Kaizer Chiefs would ever win another match, or should Bafana get an international coach? No, rubbish like that. And then they sign a minute which comes out of a precedent. They file it in court, and that was the end of it. They did not achieve anything that a pre-trial conference was meant to achieve. Well, that has come to an end. Rule 41A, there has to be actual compliance, not mere compliance, not paying lip service. You are going to comply. Now, be aware of that firstly. 41A defines dispute as the subject matter of litigation between parties or an aspect thereof. So you see, the definition of dispute is very wide. But there are certain disputes where judges will firmly focus and insist on compliance with this rule. And a good example is family law. Now, it is universally accepted throughout the world that family disputes should not be fought in an open adversarial court. Now, that is something that is firmly here in our country. Judges are not interested in listening to people's private affairs in an open court where children are involved and it's just dirty washing being aired in public. We don't tolerate it anymore. It does not belong in a court. It causes too much damage to the parties. Not the lawyers, they're just charging fees and they don't care. Well, watch it. You better start caring. The culprits are not the clients. I promise you, especially with family law cases, divorces, the matters come to court and you wonder, why aren't they settling? It's a divorce, for God's sake. I mean, surely they know when a marriage is irretrievably broken down. They know what each other's assets are. They know what to do with the children. Why haven't they settled? You will find that mostly it's because the practitioners, the lawyers, were too adversarial. And then when you challenge the lawyers, they'll say, no, those are my instructions. Okay. Why can't you agree to the usual order that the parties will have the children alternative weekends? No, my instructions are not to oppose that. There's no basis, no rational basis, okay? So the first prize with dispute resolution is to settle it without going to court. The rule requires the parties to settle some of the issues if you can't settle the whole thing. So it's not merely settling the whole matter. Now, obviously, courts are there to assist people who genuinely have a dispute. You can't force people to settle everything. But I can tell you, the majority of cases that are issued out of the registrar's office, clear majority, are settled. They never get to trial. Okay, it's something like 3% that actually ends up in court. Now, the first prize is to settle the matter. But if you can't settle the whole thing, settle the issues so that when you go to court, you are focused. And the trial is quicker, it's shorter, it's cheaper. 41A2, the rule applies to every new action or application. You are required to send a notice to the other side, whether you're plaintiff or defendant, applicant or respondent, calling them to indicate in writing whether the party agrees to or opposes referral of the dispute to mediation. You see that it is now required in writing, and you have to comply. This is a notice. Now, just let me say this to you. This is a notice. What the lawyers are going to do, they're going to say, oh, we have to do a 41A notice. Just get me the precedent or the form. Fill it in, send it to the other side. That's it. They've complied. That's what I mean when you merely comply. You have to actually comply. You have to think about it as a lawyer. Call client in and say, listen, we are obliged to try and settle this matter. Is there any basis? Don't you think we should call the other side and have a discussion over a cup of coffee? I'm not issuing summons even. I just want to, let's talk to the other side. That's how it's done, okay? Not merely sending the notice and they send you a response. My suggestion is that when you commence litigation, in other words, the first phase where you get instructions, when you obtain the facts, also in the process of taking instructions, take instructions on the possibility of a settlement, the possibility of taking the matter to mediation. If not the whole matter, certain issues can be mediated and disposed of. And of course, the possibility of settling the whole dispute without launching proceedings. Now, here's the trick. I get asked this question all the time. If we settle matters early, if we don't bring interlocutory applications, if we don't run it for 3 to 6 years, how are we going to make money? You know, if that, I hear that from lawyers during my seminars and so on. It's fine. He's a lawyer talking to lawyers. Can you imagine if members of the public heard that? And trust me, members of the public have come to find out that that happens, where you run matters merely for the fees. I'll tell you what the answer is. If you finish your matter quickly and cheaply, in the long run, your practice makes more money. Keeping a matter going for 3 to 6 years, you don't make money. It costs you to keep it running. You're paying rent, you're paying secretaries and so on. Of course, over the 6 years, the total you charged is more than had you settled it within 2 weeks of taking instructions. Of course. But remember, the legal profession is still a word of mouth profession. In other words, your clients don't come from fancy advertisements on the radio and on television. It comes from word of mouth. Satisfied clients will recommend you. There was a study carried out in Australia. You can go and read it. It's quite interesting. Where after they introduced case management, the lawyers were concluding their cases a lot quicker. 9 months, okay? The Canadians were finishing matters between 3 to 6 months, done, finalized, okay? They found that those lawyers who closed their files quickly and debited a fee actually made more money in the long run than those lawyers who ran the matter for 3 years. And that's a fact. Your practice will thrive if you get a reputation of finishing matters quickly at a reasonable price, clients happy, and off they go. Sub 3, the rule facilitates for mediation process to be introduced at any other stage of the litigation. At any stage before judgment, the parties can agree to refer a matter or a single issue to a mediator. Now, here's some suggestions, okay? Practical stuff. When you and your opponent agree to mediation, it is essential for both parties to consider the issue being referred. Now, remember, mediation is not dispute resolution in the sense that someone wins and someone loses, or where the mediator makes an adversarial finding of fact and law, or an adverse finding of fact and law against one of the parties. That's not what happens. Mediation is where the parties must believe that mediation is going to assist. The mediator merely assists the parties to reach common ground. The starting point is for you and your opponent to agree on what the issue is. What are you referring to mediation? You don't just send someone to a mediator. You have to tell the mediator, this is what we want you to resolve or attempt to resolve. You must write it down. Both the parties must have a common understanding. Otherwise, it's just a waste of time. You may also seek the guidance of the judge or case manager, where the matter has already commenced and you have to seek leave of the court for a referral. It's a good time to settle issues or to define the issues with the input of the judge. You can discuss this with the judge and come to some agreement. Sub 4, where the parties agree to a referral, the rule requires two things. There must be a joint signed minute of the agreement to refer. Do you see how seriously this is done? It's got to be in writing. Not that the parties say, okay, let's try mediation. No. It's not as informal as that. It's a formal court process now. The parties must also enter into an agreement to mediate. Although the rule discourages rigid formality, and therefore the parties are expected to sign an agreement to mediate, you may include a definition of the issues and the scope of the mediation in the agreement. That's a convenient place to deal with it. 41A6 is an important provision. It's designed to encourage people to use mediation. All communications, oral or written, documents used is confidential. So in other words, if you attempted mediation and it didn't work, then all the information that changed hands during that process is confidential. It is not, you are not allowed to introduce that into evidence. I'll be very careful about that. It's a breach of the rules of ethics if you did that, if you disclosed in court what came out in the mediation. Then there's a question of costs. It's always a question of costs. The fees of a mediator is borne by the parties equally, unless the parties agree otherwise. When a court considers an order of costs when concluding the action, the parties may then refer the court to the notices in sub-rule 2 and draw the judge's attention to the offers and tenders. Okay, so it's at that point only that what happened during mediation can be taken into account, and it can result in an adverse cost order if it appears that you did not cooperate and you did not agree with a sensible suggestion that came from the mediator. Now, there's just one thing you must remember. Again, we're behind. When you go to a mediator, or the parties agree to a mediation, you must look at the fees the mediator charges. The fees must be reasonable. Okay? Otherwise, the parties are not going to be encouraged to do this. If you get a mediator and he's charging 30,000 Rand a day, I mean, for God's sake, that's not what your client will tolerate. You see what they've done in other countries. As you know now, mediation, in 41A, is what is referred to as court-annexed mediation. In other words, the mediation is not outside the court system, it's within the court system, and the parties are compelled to use it. Where we slipped up is that we did not create a tariff of fees. Okay? Now, what they've done in other parts of the world, they've appointed panels of mediators, depending on the various skills that they need. There'll be family law mediators, construction mediators, labor law mediators. They are trained mediators, and they put on a panel that resides in the court. The The parties can then choose one of those panelists, and you will know what they're going to charge. They're confined to a tariff. Now, something similar to that is happening in Cape Town, in the Western Cape. Some of you are listening from the Western Cape. With divorce matters, the High Court in the Western Cape have an agreement with FAMSA or FAMA. It's an NGO. They mediate divorces and custody battles and things like that. And what happens there is that a judge will refer this thing to them. They actually resolve most of their matters quickly, and they charge a very modest tariff so that the parties know they're not in for an enormous bill coming from a mediator. We started the process in the magistrates' court, oddly enough. Those of you who kept abreast, if you looked at the new magistrates' court rules, the act and the rules, it provides for court annex mediation. The Law Society actually trained a whole lot of practitioners to serve on panels of mediators in the magistrates' court. And we set this whole thing up. It never worked. And you know what the reason was? The Justice Department said they didn't have a budget to implement it. So now the whole thing fell down. So they've got the act, they've got the rules, they had the panels, but nothing happened. Typical of this country. I think they stole the budget. That's probably what they did. But I can tell you, eventually that will happen. And we are also eventually will end up with panels of mediators doing this for a tariff in the High Court. And that would make life a lot easier. Now, what I want to do now is something unusual. Not talking about the rules and the directives and so on. It's very important for you as a practitioner to understand what judges do. You can't win a case if you did not persuade the judge to accept your version of the dispute. So you must understand the role of the judge. What is the judge looking for? And how can I persuade the judge to find in my favor? You'll come across judges in two roles. Firstly, as judicial case managers. You know, there are some courts in the country where they don't do this. The Eastern Cape, for example. You know, it's very funny. I was invited to speak at the AGM of the Law Society, which was being held in Port Elizabeth. You know, they take it around to different parts of the country. And the date didn't suit me. I was not available. So I said to them, listen, it makes more sense to get a judge from that division to be the speaker on this. They said, yeah, great idea. Can you find one? I said, sure, I'll phone some of my colleagues there. So I phoned them. Do you know, the first judge I called was someone who was at university with me. We're old friends. And he said, no, I'm not going to speak about case management. We don't think it's necessary in this division, so we don't practice it. It's a waste of time. That ended the matter. But you see, their role is small. The judges are not overwhelmed with work. You see, and I think that's the problem. When a court gets very busy, you need case management. And secondly, of course, you encounter judges as presiding officers. So we will talk about this. Judges want to be able to read your pleadings and be able to work out the following. Firstly, what is the plaintiff's version of what actually happened? Now, what the judge wants to read is the peculiar facts of your case. Judge is not interested in your precedent, okay? For example, those of you who have been in practice for a while, you probably wondered, and in fact, if I was the lawyer from outside this country and I read pleadings in accident cases, motor vehicle collisions, I'll think, my God, all the accidents in South Africa happen in exactly the same way. He failed to keep a proper lookout, failed to apply his brakes timeously or at all. He drove at a speed that was excessive in the circumstances. And of course, everyone's favorite. He failed to avoid the collision when he could and should have done so. I mean, who the hell knows what that means? The facts are that the plaintiff's case is that the defendant drove through a red robot and caused a collision in the intersection. Why can't you draft that? Why can't you say so? No, it's he failed to keep a proper lookout. No one knows what that means, okay? It's like a divorce. No love and affection. Who the hell knows what that means? Your client tells you that his wife beats him up regularly. So you don't write that in your pleadings. You say she shows him no love and affection. I mean, what nonsense. Now, judges are fed up of it. So draft the facts of your case. Secondly, based on the facts of the plaintiff's version, what exactly is the plaintiff's cause of action? What are the material facts which, if proved, will provide the plaintiff with the relief that they want? The facta probanda. I need to know that as a judge. Thirdly, based on the defendant's version, what is his answer to the facta probanda? What is his defense? Does he have a set of facts which will give him a defense? Now, what do you see in our courts? Bare denials. Okay, no knowledge. Plaintiff is put to the proof thereof. It doesn't help the judge. Okay. So having read the pleadings, the judge will want to work out exactly what the tribal issues are. Now, if it's not clear to the judge will expect the parties to tell him or her in opening statement. You know, one of the things we did under case management, those of you who practice in this province will know it. We say that in a pretrial conference or a case conference, whether with the judicial case manager or not, you are expected to agree on the tribal issue or issues, and you must write it down without reference to the pleadings. Then the judge knows that he's going to court to resolve this issue. The issue is, did the defendant sign the suretyship under duress? That's the issue, okay? If it's not clear from your pleadings, then you have to agree it with your opponent. Judges never encourage parties to bring unopposed and opposed interlocutory applications. Attorneys love interlocutories because they just write fees, okay? You know, I'll tell you an incident. I presented a course on litigation in Durban. This was some years back. And I told the attorneys and advocates there that they must stop this interlocutory applications. They don't serve any purpose. They just run up costs. And they agreed because it cannot be disputed that interlocutories are caused by the attorneys themselves. So this attorney, some months after I gave the course, I was in Durban for another course, and this attorney came up to me and he said, listen, I took your advice. I stopped with the interlocutory applications. And I said, and? He said, client loved it. We resolve disputes quicker. We reduce the costs. I said, and so? He says he got into trouble. I said, how? He says, well, the senior partner in his firm walked into his office and said to him, look at this file of yours. It was a litigation matter which was completed. The partner said, what are you up to? Look at this file. There are no interlocutory applications. You are supposed to bring interlocutory applications so that you can build a client. That's the whole idea behind interlocutories. It's for billing purposes. Don't do that. You're not a good lawyer when you do that. Oh, in the short run, you'll make some money, but not good for the practice. Just stop it. Judicial case management will be directed to resolving as many disputes as possible, including disputes of fact. Now, you don't need a judge to sit down with you and your opponent to do this. Why can't you do it with your opponent? Now, I'll point out to you later that if you approach a judge to case manage an issue between you and your opponent, you are supposed to first try and resolve that issue amongst yourself first. Only trouble the judge if you really can't come to a solution, okay? The next thing is you have to apply your mind to discovery at an early stage. Now, we'll deal with this in more detail later. We no longer discover everything in the office file, okay? You know how it works. You take this whole thick office file, send it to the lady at the back of the office next to the lifts, and she's the, what they call paralegal, and you say to her, do the schedules to the discovery affidavit. I mean, she knows nothing about the case, so she discovers every piece of paper in there. So you end up in court with 4 lever arch files as your bundle. And then you run a 3-day trial and you use 2 pages. It's an abuse. Judges will not allow it. You are only allowed narrow discovery. You only discover documents that are relevant to an issue. Otherwise, it's not in the bundle. Take it out. Okay. Expect a judge at an early stage to expect you to articulate what your version is, whether plaintiff or defendant. Now, here's the problem. If you're one of those attorneys who started proceedings with a superficial knowledge of the facts, in other words, you used a precedent, you're going to be in trouble. Imagine you had what happens, what happens at the moment and will happen more consistently in future is that as soon as pleadings close, the judge or the judicial case manager will call you in and say, let's go through these pleadings. Plaintiff, what's your cause of action? Let's see. I don't get it. This is a bit vague. There's not enough details. What's your client's version? Now tell me, you're sitting there with the judge and your opponent, and you don't know. You know what happens? The attorneys come up with the usual story. Judge, I'll have to take instructions and revert. Now, you know, this taking instructions and revert story, we got away with for a long time. But now a judge will say, but hold on, Mr. Jones, you're the attorney. You've been handling this thing for the past 6 months. When are you going to learn what the facts are? How come you don't know basic facts? It's embarrassing. You look like an idiot. What's the answer? Get all the facts before you issue a summons. It's only then you can make admissions of fact. I mean, how on earth will you know that you should make an admission or not? If you don't have all the facts, you won't know. And also, by the way, Rule 41A encourages parties to settle. It will be very irresponsible of you as a lawyer to engage in any settlement talks with the opponent or with a mediator if you don't know all the facts of your case. You will make a misdirection. You will cause your client severe prejudice. Okay. In a trial, always remember that the judge must first make a finding of fact, then apply the law. You must be alive to what findings of fact you want the judge to make. Now, how on earth would you know that if you drafted from a precedent? Finally, judges do not hesitate to punish litigants who do not cooperate. And this includes a cost order against the practitioners. That, just be careful. You are warned. Okay? Now, here's a very good extract from a book. It was written by Goodman. It's a very good book. It's called How Judges Make Decisions. I don't have it here. I'll show it to you later. I'll find it during the lunchtime. A judge engages with real people and real conflict. Let's stop there for a moment. When you come to court with a rubbish version, you are coming to court where there is no real conflict. You are wasting the court's time. You are the dirty dog. Where invariably the judge is faced with a choice between opposing parties and has to do the best he can with the evidence available, according to the burden and standard of proof. Okay? That's a very important statement. Judges genuinely want to help people to resolve the dispute. And they can only do that by making a finding of fact first. How does the judge make findings of fact? By hearing evidence that persuades the judge to accept one version and not the other. Your job is to discharge the onus by persuading the judge that your client's version is more likely to have happened than your opponent's version. That's the secret, okay? So you can expect a judge at an early stage to expect you to tell him what your version of the facts are, whether you plaintiff or defendant. Then get ready to make admissions of fact that are not material to the issue. The judge will actively assist the parties to define the tribal issue. And this happens where parties file vague precedent-based pleadings. It seems as if no one cares, because for years we've been preaching, plead the facts of your case. But that doesn't happen. Okay? The precedents are still being used. In a trial, judge makes a finding of fact before applying the law. Okay. Now, I've used a precedent. Can you see? I said take notice further. It is your job to assist the judge to find that your client discharged that burden of proof. Okay? There's an onus. There's a standard of proof. You have to persuade the judge or assist the judge to accept your client's version. Okay? That is what you do as a lawyer. The judge's reasoning and conclusion must be practical, suit the facts as found, and provide an effective, workable remedy to the winner. Now, you must have heard this many times before, that judges should do the right thing between the parties. In other words, the judge must act in the interests of justice. Justice must be seen to be done. That can't happen if you do not give the judge the facts. A judge cannot be expected to come to a conclusion without first informing themselves of the facts and the law. And just trust me, poor facts mean a poor outcome. That's it. Don't blame the judge. I've seen it all the time. Someone loses a case. What happens? You blame the judge. The judge misdirected himself, or the judge didn't pick up this point, and so on. It's your fault. You have to present the judge with a comprehensive set of facts where the version is likely to have happened. Then you succeed. That's persuasive. Now, sorry, Betty, when do I take the comfort break?
You can do it now, sir.
Okay, let's do it now. I'm moving into a new area. Can we take 10 minutes? Yes, can we get back at 1:45? All right. Okay, let's take a short break. Okay, Betty, can I start?
We're good to go, sir.
Okay. All right. Let's carry on. Now, before you start litigation, do the following. What are the material facts of your client's case? Get that first. Now, when I say get the facts first, I don't mean a half-hour consultation about what the case is about, and then you rush off to your favorite precedent. No, you have to get all the facts. You have to get the documentation. You have to get the names of the witnesses. You will have to talk to those witnesses. So you get the whole picture. Most practices don't do that. They do that in order to prepare for the trial, which could be months down the road, years down the road. And it's too late, because when you get to trial, you might find that your pleadings are not compatible with the version that you have. And that's always a problem. And that's what causes the postponements, because you now have to amend. Okay? Avoid that. Now, assuming you can prove the facts, what remedy can your client practically obtain? Now, do not sue for remedies you know that the defendant cannot comply with. One of the things you should investigate when you act for the plaintiff is check with client, do some due diligence. Is the defendant someone that can satisfy a judgment? This is important. You have to advise your client. One of the things you're required to do with 41A is to try and settle the matter so that the other side, the defendant, actually provides your client with some relief. There's no point in running a matter, getting a judgment, and then getting a nulla bona return out of it. Clients are not going to be happy, I promise you. In fact, clients often will say, but if you told me that, I would not have spent all this money litigating. So when you start, make an assessment of this and take instructions from client. Do you want to proceed? There's a possibility that this defendant is not going to be able to satisfy the judgment. He's a man of straw. It's a shelf company. They don't have assets. There's no underlying value. So be careful about that. I mean, it's a hollow victory if you win the case and then the sheriff comes back with nothing. So for any litigating lawyer, there's only one rule, and never forget it. Obtain the available facts first. There's no excuse for not doing that. It's facts first. And to quote a certain delinquent politician, make facts great again. Just remember that. Okay. Okay. Let's look at a further and a better understanding of what judges are looking for. I think this is important because if you have a good grasp of what a judge wants, you'll be able to plan your litigation in order to present the judge with exactly what the judge wants. That's persuasive litigation. The judge wants to read pleadings that make sense, that disclose a cause of action, that discloses a defense based on the party's peculiar facts. In other words, the judge doesn't want to read the standard precedents. A compelling version of what actually happened. The judge wants to be able to pick up the party's case concept. Now, we'll deal with that later. Basically, the case concept is what happened according to your client's version of the facts. The judge needs to know that. The version must be consistent and supported by your client's cause of action or defense. An adversarial judge is not a seeker after truth. The judge can do no more than make a finding of fact based on what the parties present. Now, you all heard of this thing called absolution from the instance. It often happens in court where the parties do not present the judge with enough fact for the judge to make a decision, to resolve the dispute. In which event, the judge has got no choice. The judge has to say, you've not done enough. I can't make a decision. I'm granting absolution. Go and sort yourselves out and come back again. Now, that is a loss. If you're the plaintiff, it's a loss. If you're the defendant, not such a loss. So what you want to do, and by the way, judges don't like granting absolution. They hate it simply because it does not resolve the dispute. The judge wants to hear evidence, in other words, facts, which must be relevant to the issue. Now remember, I told you, a judge will not walk into court and sit down if the judge and start the trial if the judge does not know what the triable issue is. Now, once the judge knows what the issue is, do not present the judge with facts that are not relevant to that issue. What is meant by relevance? It means that the facts must assist the judge to resolve the dispute. That's relevance. The facts the judge will want must be admissible. Admissible in terms of the rules of evidence. So in other words, judge doesn't want to deal with hearsay. The judge would like to hear an eyewitness account. The version, and I've stressed this, be it plaintiff or defendant, must be probable in relation to the facts of the case. The defense must equally be based on a set of facts which make up the defendant's version. Bare denials are useless, okay? By the way, if you're a defendant's lawyer and you filed a bare denial, a good opponent on the other side will actually say, listen, this is excipiable. You've not pleaded a defense. Can you amend? Otherwise, I'll be compelled to bring an application or I'll be compelled to take exception. Or, even worse for you, your opponent might convene a meeting with the judge as case manager, go to the judge and say, look, this is the plea. It does not assist the judge and it does not assist the plaintiff. The defendant either amends or withdraws the defense. A judge will sit there and say, I've read the plea. It does not disclose a defense, and you will be put on terms to disclose the defense. Now, this is the embarrassing part. You know, most judges, they don't say, okay, I'll give you 2 weeks to amend your plea. They look at you and say, hey, what's your defense? Do you have a defense? Tell me what it is. I want to hear. Now, you don't know. You say, I'll take instructions and revert. You look like an idiot. Just don't do that, okay? Now, where do you get the facts from? Now, this might sound very obvious, but it's not so obvious if you look at how many firms deal with their cases. Taking instructions actually means obtaining all the available facts from your client. This is where you get it from, a statement from client, okay? Statements from witnesses. Please don't don't go look for witnesses 2 weeks before the trial. Okay, it is too late. You may not find these people, or their memories would have failed them. It's just a nightmare. Most cases that were ripe for hearing either don't succeed or have to be postponed because a witness didn't show up, or a witness showed up and can't remember anything. You must have all the relevant documents. You know, one of the most persuasive thing for a judge is when a witness, when a party, be it plaintiff or defendant, puts up a version and can support that version with contemporaneous documentation. The documents work brilliantly. It gives the judge an independent source from which the judge can verify the evidence that was presented, the oral evidence. So documentation is vital. When you sit and consult with client and witnesses, as a lawyer, you will know that there should be a document here. The witness tells you that he delivered the goods to the defendant on such and such a day. Now you should be thinking, wait a minute, there should be a delivery note. There should be an acceptance of delivery. Where are those documents? You see, clients, especially the witnesses, they don't care about the documents. You know, it's not their business. You, as a lawyer, will have to say, but there must have been a document. They must have signed for it. Yes, they did. Where is that document? Oh, it's at the office. So you need to probe. And then there's what I call visual evidence. This is what we know as photographs of a scene, videos, satellite imagery, and so on. Exhibits. Visual evidence is highly persuasive. Take it from me, judges love it. It's something they can see, something they can hold. It helps them to verify the version of one or the other party. Where there is a potential to use visual evidence, good lawyers will always take the opportunity and procure the visual evidence and use it. So let's assume the dispute involves a scene, the scene of an accident, the scene of a shooting, the scene of a stampede or whatever. You want to do an in loco inspection immediately, like the next day or the same day. The problem with scenes or events, that the location changes very quickly. I've seen lawyers do in loco inspections just before the trial. 2 or 3 years have gone by. I mean, for God's sake, these scenes don't remain static, they change. It'll be substantially changed by the time you go and look. Go to the scene immediately. A building collapsed. Your client wants to sue. Take a digital camera, go out to the construction site, take as many photographs as you can. You are preserving the evidence, you are producing visual evidence. Things like video recordings, they work brilliantly. Don't lose the opportunity. Photographs, use them. And then there's this thing called digital information. What's digital information? In the modern era of the internet and the digital world, the opportunity for evidence is almost boundless. Let's take a motor car accident, for example. Now you have a whole new source of evidence. The car's computer or a tracking device on a car. It gives you all kinds of information: speed, direction, braking force, sudden movements. All of that is recorded. It's priceless for a lawyer. You can go to a local municipality, look at CCTV footage of something that happened involving your client. Brilliant evidence, okay? Also, in the modern world, documents are no longer presented manually or in manuscript. They're all computer generated. You must learn how to access electronically generated documents. That's another way of saying all documents these days. You must learn how to use metadata to authenticate electronic documents. Then you need to identify expert witnesses at an early stage. Don't look for an expert just before the trial. It's too late for that. Besides, we now case manage experts. You are not allowed to call an expert if you didn't take up certain steps. There's the usual steps of complying with the rules, filing the notice and the summary, but you have to get the experts from either side to meet in the absence of the attorneys and to reach agreement on the issues. They are then compelled to prepare a joint minute. That joint minute is filed. So what the judge will have is the notice, the summary, and the joint minutes. Usually, it becomes unnecessary to call the expert. And that is what the judges are looking for, okay? So how do you go about doing this? Establish that your client's version is likely to have happened, bearing in mind the circumstances of the case. A useful test is to ask, do the undisputed facts support my client's version? If it does not, you've got a problem, okay? So clients tell you what happened. You have to listen to all of the facts, get all the documents, talk to the witness, and now test it. Is that likely to have happened? So one of the things that judges do, and as lawyers, we must learn to do the same thing. Your case, your version will be made up of a set of undisputed facts between the parties. That is always the case. I've not come across a matter where all the facts were disputed. Then there's no dispute between the parties. They're too far apart. There's always a set of facts which the parties will admit or find as common cause. Good lawyer will take those facts which are not likely to be disputed and then ask a simple question. Do those facts support my client's version? If it does not, you've got a problem. Let's take a simple example. Your client sues a defendant or is sued by the plaintiff for negligent driving. The allegation is your client was speeding and failed to stop in time at an intersection and caused the collision. So in other words, it's your client's negligence that caused the collision. Of course, your client comes around and gives you a version and says, I was driving at 60 k's an hour, and it's as I got to the intersection, the light was green for me, and I crossed over. It's the plaintiff who went through a red robot and collided with my car. Now, the first thing that should strike you as a lawyer is both drivers could not have seen a green light. That's not probable. What that means is that one of the two is lying. So right there, the probabilities tell you that one of them is lying. Now, you'll be concerned that it might be your client. There's also no dispute that the police were there and they filed a report. In the report, the police have noted that your client left a skid mark of 25 meters entering into the intersection. Now let's test the version. Your client's version is that he was doing only 60. And you know what clients are like? If they tell you they were doing 60, by the time they enter the witness box, they'll be doing 30. The speed keeps coming down the closer the trial comes. You need to test it. Look at the undisputed facts. It's a clear day. The surface is dry. It is in the city. The speed limit is 60. There's a 25-meter skid mark. Now, if your client was doing 60 on a dry road, heading towards an intersection, why would he leave a skid mark of 25 meters? So what I'm saying to you is that by testing it that way, you will establish that the undisputed facts don't support your client's version. In fact, it supports your opponent's version that your client was speeding. Do you see how that works? Now, that's what judges do. They look at the undisputed facts, they listen to the two conflicting versions, and they say, if these are the undisputed facts, what are the probabilities? Whose version do the undisputed facts favor? And that is what is meant by proof on a balance of probabilities. The judge doesn't have to find truth, but merely proof on a balance of probabilities. In other words, the judge finds that the version of one party is likely to have happened, it is more probable than the other one, and finds in their favor. The judge does not have to make any finding of truth. You also have to establish, if you have supporting evidence in the form of reliable witnesses on things like corroboration and credibility, already take steps to secure the presence of witnesses on trial date. If you have witnesses, identify them at an early stage, get their contact details, get a written statement from them, signed by them, and then tell client or tell someone in your firm to keep contact with the witness. You don't want the witness to have disappeared by the time that you get a trial date. Now, here's another important step that all lawyers should take. Your client will give you a version. Your client tells you, this is what happened. Now remember, clients are not lawyers. They'll give you a story, a narrative. It is all over the place. Something happened last week, and something happened a year ago, and then something happened last night. This document was signed yesterday. It's all over the place. Your job is to listen to client first, without interrupting. Just listen. Sit back and listen. Then say to client, I've heard your story. I think this version is probable. We can present it to a judge. But let's arrange it in a chronological sequence. Let's start again. Take me through it from start to finish, step by step. And say to client, I'm going to write it down in a sequence. You must also take down witness statements in a chronological sequence. One of the things the judge does in testing a version, not only to ask if the undisputed facts support it, but a judge will also look at the sequence and say, does that make sense? And I can assure you, if your client's version is not presented sequentially and a judge looks at it, the judge might find that it doesn't make sense. Why? Because the sequence tells you this version is improbable. You've just damaged your case. Documents, absolutely crucial. Those of you who do commercial litigation, much of your case will depend on the documents, contemporaneous documents, contracts, correspondence, emails, those things. Never review documents without first sequencing them. If you don't sequence documents, you will be misdirected. It's a very dangerous mistake to review documents as they come. Clients never arrange them in a sequence, very rarely. They'll bring it in a box or in a file and they'll plonk it on your desk and you are going to deal with it. Please sequence them first. The oldest document on the top, the latest one at the bottom. Now, once you've got your client and your witnesses and your documents in a chronological sequence, now begin to prepare your first chronology document. What is a chronology document? It's a document, you could use the heading of your matter. You must have 3 columns, a very small column on the left side of the page, that's purely for numbering. The middle will be a broad column for description, and the last column will be the date. Set out in a sequence the material facts of your client's version, incorporating the documents that were handed to you. When you have such a document, it starts paying you dividends. Very important for you in case conferences. Can you imagine if you have your chronology document with you in a case conference with a judge? It tells you exactly what happened in a sequence. It refers you to the documents in a sequence. You will continually update this document as you come across more evidence. Incorporate all the new evidence and the new documents into your chronology document. Now, this chronology document you will eventually need to prepare and to present it to the judge. Now, many of you would have seen from reading directives that our courts now more and more require you to present a chronology document. If you will see that when you file heads of argument, whether it's in a trial or an appeal or a review, you'll be told, with your heads of argument, file a chronology document. We have that requirement here for opposed applications as well. You have to file a chronology document. The reason judges want chronology documents, oh, by the way, in the SCA and the Constitutional Court, you have to file a chronology document. The reason judges want it is because we know from bitter experience that judges can become misdirected simply because their facts were not sequenced. So now they will ask you for a chronology document. And by the way, when you plead, when you draft pleadings, particulars of claim or a defense, plead your facts in a chronological sequence, okay? Don't plead it all over the place. Follow the sequence. When you draft affidavits, be it founding or answering, present the evidence in your affidavit in a chronological sequence. Make it a habit, okay? Now, when you've got all the facts, you need to develop a case concept. You need to know what happened according to your client's version. It's a crucial step, as this concept will inform all of the other processes that happen before and while you are at trial. You develop the case concept from the facts and the supporting evidence you gathered. From this, you have to formulate a cohesive and persuasive story to convince the judge that this is a true version, or this is what actually happened according to your client's version of the events. That's what you want to do. This concept guides you throughout the trial, from the point when you're drafting particulars or a plea, through the pre-trial procedures to the trial itself, okay? Now, let's see how you do this. The first process. Having obtained the facts, now you have to work out your client's cause of action. Now, this is the difficult part, and this is where attorneys go running off, even counsel go running off looking for a precedent. That's where it goes wrong completely. It is admittedly one of the most difficult tasks for many practitioners. How do you take a set of facts, a story, a version, and turn that into a sustainable cause of action in law? There is a method. First of all, a warning. Whenever you encounter a set of facts or a version that seems implausible, in other words, you don't believe it, stop, clear it up. Do not proceed to draft anything. Do not proceed on the basis that, well, those are my instructions. You are heading for a confrontation with the judge. And besides, it's very plain. You will not succeed in court. You will end up with a version that's going to be disbelieved. Simple as that. So what is cause of action? Let's define it. It is a set of facts giving rise to a claim recognized by law. Put differently, it's the facts that the law recognizes as giving you a claim. So remember, cause of action is not a legal concept. It's factual. You can't have a cause of action without the material facts. So you first assemble the facts. Now ask the simple question. If I prove those facts in court, what does the law say I'm entitled to? So if I prove that the defendant drove negligently, and I can say what the negligence was, if I can prove that, what does the law say? The law says if I can prove that, then the defendant was driving negligently. That in turn means that you're entitled to compensation. Do you see how it works? The same with the contracts, okay? So how do you formulate it? Let's take you through the steps. Now, those of you who, you should get this book of mine, The Practical Drafting Skills. Many of you have it already, I know. This book tells you step by step how to formulate a cause of action. It also tells you the rational reasoning, the logical reasoning that goes into it. Now, I'll use the same logic here. You've got a story, you've got a version. What you do is you write down, using numbered paragraphs, the material facts of your case, okay? What are the material facts of your client's version that caused him prejudice, that he wants relief? You will extract all the main facts that represent what happened according to your client's version of what happened. Using numbered paragraphs, exactly what were the consequences for your client. Itemize the loss or damage suffered by your client. Now, this is the rough notes. Now, here's a practical tip. When you draft particulars of claim, or an affidavit, or heads of argument, or an opinion, you're a fool if you think you can pull that off by taking your pen and paper or opening up a file on your computer and go from introduction to conclusion in one go. It doesn't happen. You have to be an extraordinarily talented lawyer to do that. How it works is that you first get your rough draft. Now, I can assure you, once you have a rough draft, from that point onwards, it gets easier. The difficult part is to get that rough draft done. So how do we go about it? When you've written the material facts, numbered paragraphs, you wrote down the consequences to your client and you wrote down the damages. At the end of this exercise, you will understand the context of the matter. Now, what is meant by context? You have to contextualize the dispute. It means that once you've got all these facts, ask yourself, what area of the law is this? Is this medical negligence? Is it a contractual dispute? This is a building contract. This is about copyright. So you have to categorize and contextualize your facts. The law is vast. But in order to establish your cause of action, you have to first work out what area of the law is this. If your knowledge of the facts is good, you will have no difficulty in identifying the appropriate area of law. It shouldn't be a problem. Sometimes it covers more than one area. That's fine. You can then plead in the alternative both those areas of law. For example, you would find that a case may belong in contract and at the same time delict, or both. Okay. What you have to do is convey to the defendant what is being demanded of him and what is the basis in law for the demand. That's the cause of action. Once you've got the facts, you've arranged it sequentially, you've written down the material facts sequentially, you've worked out which area of the law. Now you have to go and read the law. Find out what the law says is the remedy if you are able to prove these facts. So you see how important it is to get the facts first, because you can't look at the law, you can't apply the law until you've got the facts. The law then tells you what your remedy is, should you succeed in proving these facts. Now, the material facts, you'll have to plead them sequentially, and then you have to say why the law favors your client with a remedy. And what is that remedy? Find out what are the essential elements or ingredients or material facts for the proposed cause of action. Write it down. Each element in a different numbered paragraph. So at this stage, you've done two things. You've got a list of your client's material facts, and you've got a list of what the law says are the essential requirements for that cause of action. What you've done is that you created the legal framework for your cause of action. You have virtually got your rough plan. Read through what you've written and now ask these questions. Can my client's facts be sufficient to satisfy the essential elements of the cause of action? In other words, the material facts. If not, then there are gaps in the version. And you have to take further instructions. Okay, so what you're doing is you're looking at these material facts, and now you're looking at the legal requirement, and you're going to say, will these facts of mine present sufficient proof of the legal requirements? If the answer is yes, you're good to go. Draft it. If the answer is no, then you need further instructions. Something is missing. Can I provide proof of the facts in the event that the defendant disputes them? Now, initially, you must expect the defendant to dispute the facts. Later, before trial, you will ask the defendant to make admissions of fact that are not material to the dispute. So you'll narrow the factual dispute down. You must know who the witnesses will be and if they're available. What do documents tell you? Do they support your client's version? Or do they contradict it? Do I have contemporaneous documents that I can use to prove my case? Now, having answered these questions, you would have established the cause of action. So you see, this whole thing is about using your skills as a lawyer, thinking it through, applying your mind, not using a precedence. So you have two lists of facts. They represent the facts that the law recognizes as giving you a claim. That's the definition of cause of action. And I've recommended you look at practical drafting skills, follow it step by step, and you'll be able to write without using precedents. I've come across many practitioners who keep that book on their desks, and they are saying that they've learned to draft without using precedents. Now, there's something that you have to understand. Formulating the cause of action, then writing it in the form of particulars of claim or a plea, requires careful application, requires you to work pretty hard. There's always a temptation to take the shortcut and use a precedent. If you have to use a precedent, then first draft on your own, then compare it to a precedent. The secret of becoming good at writing, at drafting, is if you do it yourself. Back yourself, write a lot, write your own work. It gets better with practice, okay? But if you're not prepared to put in the work and you take the shortcut, you use the precedent, I promise you, you'll get into trouble. And very soon, you'll find yourself in the Wills and Estates Department where you belong, okay? Or worse, Or better still, you can open a Chisamnyama somewhere, you'll be better off. If you act for the defendant, this is the difficult part, okay? Well, it's not so difficult because it's easier to figure out. Because you know that the rules tell you that as a defendant's lawyer, you have, or the defendant has to answer the substance of the plaintiff's claim. In other words, you have to take each of the material facts in the particulars of claim, and you have to admit, deny, confess, and avoid, and fourthly, set out your version of what happened. That's what you have to do. Now, if you deny, you must be able to say why you deny. Okay. Now, you have to go through the plaintiff's particulars of claim, paragraph by paragraph, material fact by material fact, and come up with a response based on the defendant's version. Not so easy. You will often find that you just cannot answer some of the material facts. Nothing wrong with that, because in most disputes, the defendant will admit some of the plaintiff's facts. There's no harm in that. In fact, you are expected to do so in order to narrow the issues. Now there's this question of onus and duty to begin. When you draft particulars of claim or the plea, apply your mind to the question of onus and duty to begin. Now there are two different things. Onus will always be on the plaintiff, but the duty to begin doesn't necessarily remain with the plaintiff. Let's give you a simple example. Plaintiff relies on a suretyship signed by the defendant. Defendant admits that he signed the document, but pleads that he did so under duress. Now, once the defendant pleads, admits the signature, but says he did it under duress, what that means now is that the defendant will attract the duty to begin. So in the trial, plaintiff will stand up and say, my lord, here's the original deed of suretyship. Defendant admits the signature. I rest my case. The duty to begin is with the defendant. Now, it is not a good strategy if you're a defendant's lawyer to attract the duty to begin. Why? Because you always want the plaintiff to start first, so that you get the advantage of cross-examining the plaintiff's witnesses first. So when you plead, try not to plead in such a way that you attract the duty to begin. Sometimes it is unavoidable, like the suretyship example. Your client will say, yeah, that's my signature. So why did you sign it? Are you bound by it? No, I'm not bound by it. I was forced. Let me tell you how they forced me. And he tells you, okay? There, you know that you're going to attract the duty to begin, and it shouldn't be a problem for you. Now, let's look at the next phase. And that is when pleadings close. As soon as pleadings close, you have to call client in. You have to do the following. How do the pleadings impact on your case concept? Do you have to adjust your case concept? Now remember, the version that you started with, which supports your cause of action and which supports your case concept, may need adjustment. For example, when you started drafting particulars of claim, you had no idea what the defendant's plea will be. You may have to make some adjustments, even amendments, after you see the plea. You then get documents that come. Your opponent discovers documents. There's a document there that does not support your case. You may have to make an adjustment to accommodate that document. What facts have become undisputed? This is crucial. When pleadings close, it is at that stage where you can revisit the facts and ask yourself, what facts are not disputed now? Because you've got the plea, okay? A good lawyer makes a note of each of those facts. Which of the material facts have become disputed? Now, that would be the disputed facts will define the issues between the parties. You will have to apply your mind as to how you go about proving these facts. Okay? You will have to carry out a proof analysis. What is a proof analysis? It's something lawyers don't do. It gets them into trouble. You have to look, pleadings are closed. You have to look at your particulars of claim now and look at the answer from the defendant. Now you have to write down those facts that are undisputed, and then you write down those facts that are disputed. Now, you know that the undisputed facts you don't have to worry about. You don't need witnesses. The common cause facts, you don't need witnesses. But with the disputed facts, which will formulate the issues between the parties, you will need to prove your version of those facts. Your opponent will want to convince the judge that their version is the more persuasive. Now, you carry out a proof analysis. Take each material fact and ask yourself, how will I provide the judge with proof of those facts? What that means is, what documents will I need? Who will be my witness? Do I have a credible witness? Or do I need to look? Where's the document? Is this an original? Is it an electronic document? Do I have the metadata? So you will do a proof analysis. You will have a list of witnesses, name, and what that witness will say. It must be relevant to a material fact that you have to prove. If you have witnesses who are not relevant to any of the material facts, send them home. You don't need them anymore. So, if you're the defendant, look at the plea. Does it disclose a defense? Do you have an answer? At this stage, you are also going to update your chronology document. Okay. Finally, most importantly, can you identify the issues between the parties? This, I suggest you write down in your own words. Do not copy from the pleadings. It's an essential step. The case managing judge will require you to do so. What you're supposed to do is call your opponent and say, listen, we have to contain the issues here. What do you say is the most material issue? That one issue which, if it's resolved, will finalize the whole case. There may be 3 issues, but there's always that one issue that will be decisive of the whole case. You don't have to prove the other 2 issues if you can prove this one issue. That's the way to analyze it. Now, how do you do this? You do it in a case conference. Call your client to a case conference. have a meeting. On the agenda, admissions. On the agenda, agreement on the triable issue. It will be in the agenda and you will discuss that. It will be minuted and you will write it down. And now we get to discovery. This is absolutely crucial step. I find that practitioners actually underestimate this. Or rather, they underestimate the importance of it. Once you have identified the issues, now identify the relevant documents you require. Courts do not encourage wide discovery. Be careful. If you now go to court with 4 lever arch files, you go to court and you very bombastically tell the judge, "My lord, may I hand up the plaintiff's bundle?" And you hand up 4 lever arch files. You need 3 candidate attorneys to carry it to the front. Well, it looks impressive, but if you run the trial and you use 3 pages, the judge will have no hesitation in disallowing you the costs of your 4 bundles. That is a disaster for an attorney, okay? Because that's money down the drain. In the past, we discovered everything. Handing up 4 lever arch files was not unusual. In fact, it was the norm. Attorneys loved it because they charged per folio, okay? It made a lot of money for them. Firstly, putting together the bundle. Then they will charge on perusal of 800 pages at so much a page. And they charged a fee. By the way, I don't know many attorneys who actually perused the 800 pages. It's all done by the cost consultant who gets the file and goes 1, 2, 3, 4, 800. 800 times so many rands per folio. Money for jam. We now consider that to be an abuse and it's not allowed. This is a very important concept. Why? Because judges love it. When you consult, obtain the facts. To obtain the facts, be alive to the presence or potential presence of contemporaneous documentation. I dealt with this. These documents are crucial and it will help your client discharge the onus. Why they are crucial is because they persuade the judge. So you have a witness giving a version, an explanation of what happened. And they also say to the judge that there's a document. At that time, the defendant signed acknowledgement of receipt. Here it is. It's on page 5 of the bundle. Judges love it because it provides credibility. It supports the oral evidence. You must use these documents, okay? And I told you, we don't tolerate opposed interlocutory applications over discovery. I must tell you, I was sitting in court recently, and there were 2 senior counsel, silks. One had flown in from Cape Town. To do what? They were having an argument over discovery, over what should be discovered and shouldn't be discovered. When I was the next matter, so I asked them, how long you guys going to be? They said, no, we won't be long. Half an hour to 45 minutes. I said, well, it's discovery, it can't be long. By lunchtime, they were still arguing. Can you imagine the costs that they ran up over some dispute over the admission of a document or whether a document should be discovered or not. We don't want that to happen anymore. The parties must get together, the attorneys and the advocates, and reach agreement. If you can't reach agreement, go to the case manager and say, we're having a problem with this. How do you propose we deal with it? Okay. So you can get a ruling in chambers. Don't run up costs with these discoveries. Now, this is very important, especially now. Those of you who do commercial work, this is absolutely crucial. E-discovery, in other words, discovery of documents that are electronically sourced or produced, that is these days all the documents, okay? It is the retrieval of materials originating from a computer, and it extends beyond computer files to encompass the analysis, gathering, processing, review, and production of discovery materials in electronic format from start to finish. That's the definition of e-discovery. The principle is that information which is stored, used, or transmitted in an electronic form should be available through discovery with the same openness as traditional forms. Now listen, there's no secret or nothing special about e-discovery. The same principles that apply to conventional discovery applies here. In other words, relevance and proportionality applies here. The same principle applies that documents must be admitted if there is no meaningful or rational reason not to do so. So the parties again have to sit down and reach agreement on the admissibility of those documents, okay? You can look at my book that I wrote with Terry Harrison on a guide to e-discovery. It's available with Lexis. It's a very useful book. I'll tell you what's good about that book. We got permission from the United States to publish a glossary of terms. It's in the book, and it's a very useful thing for you to have. Okay, now we're dealing with case conferences. And I say you can win your case right here. Practitioners underestimate the value of case conferences. When I talk about case conferences, I'm referring to your formal pre-trial conferences in terms of Rule 37, I think it is. I'm also talking about case conferences that you call with your opponent. And I also refer to case conferences that you call with the case manager, a judicial case manager. When you attend a case conference, you are expected to actually achieve the purpose of the conference. You are not merely to comply. You see where this mere compliance came from? This happened many years ago. It's probably about 30 years ago, where the judges realized that the parties are not taking pre-trial conferences in terms of Rule 37 seriously. Then what the judges did, they said that you will not be allowed a trial date if you don't file the minutes of the pre-trial conference. So now they thought they'll force the attorneys into having a pre-trial conference. Well, they did it. It worked. Except that the attorneys decided, well, all they have to do is comply by filing a minute, and then we'll get a judge. We don't have to really do what the pre-trial conference was for. So they created a precedent. In fact, the same precedent ended up circulating all over Johannesburg, and in every case, you found it in a court file. It said nothing, okay? We don't do that anymore. Okay. That's where case management comes in. Those of you who have access to the Gauteng practice directives, go and look at the directive on pre-trial conferences. What we did in Johannesburg, this happened years ago, we created a list of items that must be discussed and agreed upon in case conferences or the pre-trial conference. And set out, there are 13 of them. Go and look. What the attorneys did, they took that list and they copied and pasted it on a piece of paper, and next to each question they wrote yes or no. And they just tick, 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 signed it and put it in the court file. Hey, they complied. We have to give them a judge. You see, well, that doesn't happen anymore. Now your minutes will be scrutinized by the judge. And if you did not cooperate, now there are those attorneys and advocates, you will have come across them, you might even be one of them, that either doesn't attend a pre-trial conference or attends it and comes unprepared and ready to be adversarial and not admit anything. Those people are actually a nuisance to the system. Go and read, and I insist you must read Rule 37.9a. It's been there for a long time, but judges did not use it, and practitioners got away with all kinds of abuse. 37.9a says that where a party or the legal representative does not cooperate or does not take reasonable steps to resolve a dispute, the judge can penalize the attorney or advocate with a punitive cost order. It's there. Judges are now beginning to use it. Be very careful. If you go to a pre-trial conference and you become difficult, you don't cooperate, you don't agree on anything, you only want to take instructions and revert, and then you don't revert. All of those tricks, you are busy pulling them off quite effortlessly. What you don't realize is all of this is in the minutes. Okay? Always keep accurate minutes. I suggest, if you anticipate that your opponent's going to be difficult, when the pre-trial conference starts, you must have an agreement to record the meeting. Okay. Recording works brilliantly because once the machine is switched on, that's when the lawyers stop talking nonsense. They deal with the agenda and they'll get up and leave. That's what you want. You don't want any funny comments or bravado or grandstanding, which often happens in pre-trial conferences. So if you don't cooperate, a judge can, in terms of his inherent powers and in terms of Rule 37.9a, penalize you with a cost order. Okay, so be careful. What to expect? What do you do? Firstly, focus on what you believe to be the tribal issues between the parties. Often this does not emerge from the pleadings. It's a good habit for you to write this down separately, and this is what a judicial case manager will require. But this is what your opponent will require. You see, the best way to deal with this is to put it on the agenda and say that each party will present in writing, without reference to the pleadings, what they believe to be the tribal issue. Now, often this works out very well because the parties both agree on the same thing, and right there you've got agreement done. If you can't agree, then you put down each party's suggestion as to what the issue is, and that can be debated in front of with a case manager, or it can be debated with the judge in opening statement. Then a crucial step, reduce the number of issues. Define the issues, then work out which issue will be resolutive of the whole case. Okay. You know what a good lawyer does? Good lawyer is one who can hear a case and put his or her finger on that one point that will resolve the whole matter. That is something that doesn't come naturally. You will learn it with experience. The more experience you get, the more you will be able to do so. A judicial manager will insist on it. We always recommend, it's recommended that you discuss it with your opponent, reach agreement, and then attend the case conference with the judge. That way, it's more practical because you'll say to the judge, Judge, here is we've agreed that this is the trial issue. Hand it to the judge. The judge looks at it and says, fine, I'm happy with it. It's done. Now, this is an important part, and it creates a problem for lawyers. You must request, and in some cases demand, admissions of fact that are not material to the main issues. One way to restrict the court time that you take up is by making admissions of fact so that the parties don't have to prove everything. A good strategy is for you to work through your case concept, the pleadings, the discoveries, and write down those facts which the defendant or the plaintiff has no basis in law to dispute. Write them down, make a list. 2 weeks before the case conference or the pretrial conference, send the list to your opponent and say, at the hearing, we will be seeking, on the agenda, we will be seeking admissions of fact. Here is a list of the admissions we seek. We require a response on the day of the conference. Now, what's the advantage in this? The advantage is it tells the other side what you want, and it gives them an opportunity to take instructions. If you don't do this, what the other side will do is when you get to the case conference and you say, here's a list of my admissions that I want, they'll look at it and say, oh, we'll have to take instructions and revert. So it's a waste of time. By the way, just a practical tip again. If for whatever reason, your opponent says, I'll take instructions and revert, then do the following. Firstly, agree that they will revert in writing. There's a reason for that. When they revert in writing, then the written revert is attached to the minutes and you've complied. Because there's a practice directive here in this province, it's been there for a long time, that if you promise to revert in a pre-trial conference and you don't revert, on the day of the trial, you will not get a judge. You will need to fix those minutes first. Go and take instructions, deal with the reverts, and come back. You know what that means? In a place like Johannesburg or Pretoria, it means you lost your place on the roll. You end up at the back of the queue. Okay. Now, here's the second reason why you want it in writing. is that you will also say, we want it in writing, your revert in writing, and let's agree on a date by when you will give us your revert. That's crucial, because the lawyers have a habit of saying, we'll take instructions and revert. They don't tell you when, and then they just forget about it. They ignore it, okay? Now, this is the last point I want to make here, because I'm out of time. Should your opponent refuse to make an admission, don't accept it, okay? You must say, we note that you refuse to make an admission. Now, please tell us, for purposes of noting it in the minutes, what is your factual or legal basis for refusing to make the admission? Tell us, we're going to write it down. If you've got one of those impossible opponents who refuses to make any admissions, they will be in trouble. So they're not going to listen to you. They'll come up with another excuse, famous one. It is a matter for evidence. Okay, fine. Write that down. What you will do when you get to trial, when you make your opening statement, you know that they've got no basis to refuse an admission. Tell the judge, say, my lord, may I refer you to page 3 of the minutes of the pretrial conference. Those were admissions we requested. My learned friend refused to make those admissions. I am giving fair warning that I'm going to call witnesses to prove those facts. And if they are not challenged, my lord, I will be seeking a punitive cost order. Just do that. You will see how quickly your opponent will ask for a short adjournment, and they'll make all the admissions quickly, because a judge will punish them if they don't challenge the witnesses. And it will be a cost order. Possibly de bonis proprius, and also possibly in terms of Rule 37(9)(a). The whole idea is to reach agreement without having to resort to orders for compelling. In other words, interlocutory applications. Okay? Right. Let's see, where have I gone to? Okay, let's carry on with this. You must be ready to discuss the presentation of documents and the composition of the bundle. That's always been one of the purposes of a pretrial conference, except now two main changes have taken place. Firstly, your documents are not going to be your usual hard copy documents. Your documents will be electronic documents. They'll be on a hard drive on a computer. If you print it, it doesn't necessarily mean it is that document. You'll have to reach agreement. So that's the one thing that has changed, electronic documents. And the second thing that has changed is that the judge will only allow narrow discovery. In other words, you only discover documents that are necessary or relevant to the issues before the court. Your judges also apply the principle of proportionality. In other words, you don't discover on an extravagant scale where the costs are so high that it is not justified by the value of the remedy that you are seeking. You know, you could have a 800,000 Rand claim and spend 3 million on discovery. These days, with electronic documentation, that's exactly what can happen. Some of you may be familiar with this famous case of McCarthy versus Vodacom. This is the please call me case. The matter, after 10 years, is still not resolved. Currently, the parties are having disputes over discovery. The plaintiff is saying, we need to calculate what you owe me. I want the data, or I want the documentation for every call that was made using that technology. And we want to see what you made out of it. Now, there were billions of those calls, okay? And Vodacom said, well, we don't have them. Here's the problem. Electronic documents are very hard to lose. They may be in another form, but they'll still be there. They'll be on a hard drive somewhere. The only way you can destroy them is if the hard drive itself was completely destroyed, okay, smashed or burnt or whatever. As long as there's a hard drive which had the information, you can retrieve it. So you need to have a sensible approach. Judges will not allow you to document bomb the other side to mark them in costs. It has to be relevant, narrow, and proportionate to the dispute. The parties will still have to agree on the trial bundle. These days, it's done on case lines if you're in this province, and it will be on case lines in the other provinces soon. As soon as the department deals with all the corruption that's going on, they'll roll it out. Case lines will come to all the provinces. At the moment, it's only available here in Gauteng. You will then you will have electronic bundles before the judge, numbered in a sequence, easy to use, indexed and paginated, and it will be a small bundle. Most of the documents you'll have two bundles. One bundle, which contains documents that are admitted, and another very small bundle, maybe 2 or 3 documents at the most, which require proof or authenticity. That's where you will come to court with the metadata, and you will prove that the document was not tampered with or altered in any way. Okay. Okay, we'll deal with experts tomorrow. There's quite a lot to deal with here. Betty, is there time for questions?
Currently, there's no questions, sir.
Okay. Make a note of the questions you have from today's discussion, and tomorrow I'll make some time to answer your questions, okay? I don't want to keep you too long. We've run out of time, and it's quite exhausting to concentrate on a screen, you know. A live presentation is always better. All right, we'll log on tomorrow, and please remember, if you were unable to attend the whole thing due to load shedding, we'll accommodate you. Just let Betty know. Okay, thank you. Talk to you tomorrow.